Well, the safe harbor deadline has come and gone. That is the date when all state challenges to the election are supposed to be completed, and it just is not over yet. Joining us now to talk about where the lawsuits stand is John Malcolm. He's the Vice President for Constitutional Government at the Heritage Foundation. Thank you very much for joining us. We appreciate it.
Sure.
So tell us again the significance of this date, because we went back and forth with experts yesterday as to whether or not the date actually holds true or there are other dates that it could be pushed back to.
Well, it's the date for states to certify who their electors are going to be. But the electors don't vote until December the 14th, and their ballots aren't counted until January the 6th. In the meantime, Texas has filed this action against these four states, Michigan, Pennsylvania, Wisconsin, and Georgia, in the Supreme Court. Supreme Court has original jurisdiction of lawsuits between states, and four other states so far, Alabama, Louisiana, Arkansas, and Missouri, have indicated that they want to weigh in on Texas's side. The Supreme Court has apparently issued an order asking the defendants in this lawsuit to file a response by tomorrow, and I suppose it's possible. I still consider it a little unlikely, but I suppose it's possible that the court could decide to hear the case on an expedited basis and enjoin the electors from casting their ballots. Texas is asking for a rather dramatic remedy. They're asking for those four states to have a special election, basically a do-over for their presidential election. And if they don't get that, then to toss the certifications and require the state legislatures to designate which slate of electors they wish to send or not send any. So it's all last minute, but these are very, very serious challenges that Texas has raised. Their brief is excellent. Their complaint is well thought through. There are some significant constitutional issues, primarily involving what's known as the Electors Clause. And we'll see whether the court chooses to take up the case.
Yeah, whether the merits stand or not, there's still the issue, I assume, of states have the right to determine their own laws within that state and determine who goes. People don't realize the Constitution actually doesn't give you and me the right to vote. So that's up to state legislators. So how does that play? Is that a weakness in their argument?
Well, that is the crux of Texas's argument. So Article 2, Section 1 of the Constitution contains the Electors Clause, and it essentially says that the electors, and that's who selects the president, shall be chosen in a manner to be designated by state legislatures. What happened, and so state legislatures pass election laws, and that's how electors get chosen. What happened in this election is that some state court judges, federal court judges, and some state election officials, not state legislatures, changed the state election laws because of the pandemic. And so the challenge is none of those changes, whether they were to notarization requirements or signature verifications or by when ballots had to be received, whether there had to be a detectable postmark and the like, none of those changes in these four states were ever ratified by the state legislatures in those states. And therefore, those state court, federal court judges and state election officials were acting outside the bounds of the Constitution.
John, I want to go back to what you said in reference to what happens next with this, because the Supreme Court gave these states, these four individual states, until Thursday to respond. And we do have at least this response from Michigan's Attorney General. In it, she says, the motion filed by the Texas Attorney General is a publicity stunt, not a serious legal pleading. And then it goes on from there and wraps up by saying that Mr. Paxton, Ken Paxton, the Attorney General in Texas who filed it, that his actions are beneath the dignity of the office of the Attorney General and the people of the great state of Texas. Do you expect a similar response from the other states? And what exactly is it that they need to do in order to respond?
Well, that's not really a response. That's a press release. They're going to have to file a legal brief in court and trying to rebut the allegations that have been made by Texas, and also Texas's argument as to why the court should take up the case and take up the case now. That will be their response. So we'll have to see how the judges respond. It is a serious complaint. It is certainly coming up at the 11th hour, and the remedy that they're requesting is a rather dramatic one, but it is by far not a frivolous. They are not raising frivolous issues. These are serious issues, and they will have to file a formal response, not just give the Texas Attorney General the back of their hand.
Yeah, and they have not agreed to hear it yet, but it's on the docket, and that's why they've asked for the filings, correct?
That's right. Yes. Okay. So once they receive that response, 4 of the 9 justices would have to agree to hear the case. And of course, it takes 5 justices to win a case, but that's the rules. If 4 justices want to hear the case, then they will hear it.
All right. Thank you for shedding light on this, John Malcolm. Thank you, sir.